Hello, everyone, and welcome to the Labour Justice Barometer podcast. I'm Aisha Adam.
And I'm Debbie Collier.
And we're your hosts today on the Labour Justice Barometer. On this episode of the Labour Justice Barometer, we look at the case of Gugwini versus National Consumer Commission. And this case revolved around issues of disability discrimination and reasonable accommodation. Now, the employee in this case was a senior researcher who was declared legally blind and permanently unable to read and write. The employer, who was the National Consumer Commission, offered alternative options, including a lower-level position at a contact center. Now, the employee rejected the lower position, expressing that it was demeaning, and instead they requested training and assistive tools for an ICT position which was vacant and which the employer found unsuitable given the role's inherent requirements. So the employee alleged unfair dismissal based on disability discrimination, and the employer argued that no, the dismissal was due to incapacity, not discrimination, and that the employee could not fulfill the inherent requirements of this position, even with reasonable accommodation. This case was actually brought to the Labour Court, and the court found that the dismissal was fair as the employee was unable to meet the inherent requirements of the job. And it was determined that reasonable accommodation cannot require an employer to modify a position so fundamentally that the inherent requirements are removed. So the court dismissed the employee's claim, stating that the dismissal was due to incapacity and the inability to perform essential job functions and not discriminatory conduct. In today's episode, we'll also be touching on the Letimile versus CTICC case, which involves Letimile, a wheelchair-bound employee who filed a lawsuit against CTICC alleging unfair dismissal and discrimination based on her disability, race, and gender. Now, the case is still before the courts and it has been set down until February, but it is still relevant to our discussion today. Just to give you a bit of a background, Letimile was hired as part of the CTICC's Targeted Recruitment Initiative for Disabled Persons. In 2016, she contracted TB meningitis, which resulted in her being wheelchair-bound and experiencing disability-related complications. Despite promises, the CTICC allegedly failed to provide the necessary accommodations such as training, equipment, or even sensitivity programs for disability awareness. Now, Letimile accused the CTICC of neglecting its duty to reasonably accommodate, and she claimed that the CTICC's response to her advocacy efforts around disability awareness and health-related matters, including her use of assisted devices for incontinence, was high-handed and silencing. Now, Letimile was retrenched during COVID, and she alleged that her retrenchment was unfair and discriminatory as she was not adequately accommodated or consulted to during the process. So starting off with the Gugwini case, what are your initial thoughts, Debbie? Do you agree with the decision?
Aisha, the outcome, perhaps. We still have some way to go in terms of understanding our obligations on how to manage persons with disabilities in the workplace and how to manage requests for reasonable accommodation, and whether or not we are truly understanding and applying our current law on our international law obligations towards persons with disabilities.
Was there anything in particular that you can say that you didn't agree with or what you did agree with? Maybe let's start off with what you didn't agree with.
So I guess what stands out for me, and when we deal with persons with disabilities, we obviously have an inherent understanding that there needs to be, or in any request for reasonable accommodation or disclosure of a disability, the process becomes important. The possibilities of pursuing a dismissal route, obviously the code of good practice on dismissals and the incapacity aspects of that come into play. But way before we get to that point, we should be looking at what the Employment Equity Act says around reasonable accommodation for persons with disabilities. And in this case, it just appears to me that the employer has jumped right into that second stage, that incapacity process, that leads you down the track towards a dismissal, as opposed to that initial process around reasonable accommodation of persons with disabilities. When we read judgments, we're limited in our understanding of the case to the facts as they're set out. And obviously, judges are under constraints around writing judgments, as even more so the CCMA. So it's not as if there may be other aspects to this that we're not privy to. But in paragraph 4 of the judgment, we get the picture of the employee who is registering his incapacity because of his visual disabilities. And there's a note from his doctor saying that an occupational therapist was needed to indicate to what extent he was likely to be able to perform specified activities. And nowhere else in the decision do we get a sense at all that any evidence is presented, any reports were obtained from an occupational therapist. And it just seems obvious to me that you want to get a specialist in to do that assessment. So who's making those decisions around whether or not accommodation is possible? What adjustments does the employee require in order to perform a position, whether it is their current position or an alternative position. I don't see how particularly a person with a disability can necessarily know themselves without having the input from an occupational therapist or an expert of that nature. Whereas here, it seems the inquiry was limited to an HR assessment, a doctor's note saying get input from an occupational therapist. And I think in the assessment or in that process, that aspect may not have been pursued as well as it should have been.
I can easily say I don't think this was done properly. I think I agree with you that when it comes to those proactive accommodation measures, I don't think those were done very well. I think there was more the employer could have actually done to support the employee. But now taking that into account and looking at how, the labor court examined and actually, decided on how this should proceed, do you think that this decision actually reflects the current state of law?
Actually, I think the labor court decision gives a good overview of what is required in an incapacity hearing. And an incapacity hearing is typically, and it finds its genesis in the code on dismissals, which for me in itself, that articulation suggests, a particular road has been, a particular path has been embarked on. I think more emphasis could have been placed on the provisions under the Employment Equity Act and the Code on the Employment of Persons with Disabilities, which entails an employer, having been advised that an employee has a disability and is seeking ways to accommodate the employee. In terms of the jurisprudence, certainly the decision in the CCMA, the Standard Bank case, is important. Again, that's largely around the incapacity hearing and seeking alternative accommodation, and whether or not the current position can be adjusted, so that the person with disability can perform that role. The law is relatively clear, and the Labour Court picks up on those key aspects. I think a bit more on the interplay between the regulations, or at least the code of good practice under the Employment Equity Act may have been useful. A discussion on that, I think, even more so, what was perhaps could have been dealt with in the decision is whether or not the employer had adequately engaged in the process. Whether that process is under the Employment Equity Act or whether the process is under the Labour Relations Act, it should involve the opinion of an expert in the occupational needs of persons with disabilities. And I think it's the application, really, our legal requirements in terms of the Employment Equity Act that perhaps could have been dealt with differently.
I think that's a key point, that we don't know who actually performed, the assessment. Was it a human risk manager? Was it a human rights manager? Was it someone else in HR, or was it an expert? And I think so that actually is something that I think we will dive into a bit later on. But before I get into that, I actually want to ask you, what do you think what implications does this case have for employers in terms of their duty to reasonably accommodate? Does an employee's inability to offer an alternative position absolve them of liability? What do you think about that and how this was applied in Gugwini?
The difficulty that I have with this decision, Aisha, is that we talk about the employer's inability to offer an alternative position, but I'm not sure that it was really fully explored to the extent that it could have been. And obviously, our law is clear on not placing an undue burden or hardship on the employer. But really, in the absence of, an assessment by an occupational therapist, in the absence of a very good understanding of what sort of support or assisted aids, with technology, certainly within the workplace, and even, in the academic environment, students with visual impairments are often, supported with relatively low-key, low-cost interventions that can provide them with the tools that they need to accommodate them in those contexts. So my concern just is the extent to which his ability to perform the job has been assessed. And with the judgment itself, it's perhaps the extent to which the court really engages with that, whether or not the employee has been given the full opportunities by the employer to understand the extent to which their disability is in fact an impairment for performing the job.
I mean, thinking about the case of Gugwini and thinking about what the employer did to reasonably accommodate him, in this case, we know that, he was advised of vacant positions in the business, and he had three options: an ICT position, which he had proposed, and in respect of which I think the employer didn't believe he had the experience for it, a lower position at the call center, or medical boarding. And I mean, in this case, if we think about it, what implications does Gugwini have for employers in terms of their duty to reasonably accommodate employees with disability?
The employee was indicating their willingness to act in the position of the ICT role. That seemed to be the preferred route that the employee would have ultimately desired in terms of reasonable accommodation. The employer's response was to ask him to provide a motivation, a motivation as to why he should be appointed to the position, a motivation to explain his suitability for the position, and why this position should be offered to him. And the employee doesn't do so. But I'm not convinced that that is what the employer should have done. The employer should have engaged on the inquiry. It's not about the employee's motivation at this stage. It's about whether or not the employee can be reasonably accommodated to fulfill the role, to meet the requirements of the job. And that's not within the knowledge of the employee to provide in a motivation. That would have been forthcoming from an expert, like an occupational therapist, who's familiar with the environment and what tools are available. And then the suitability of, once those are known to the employee and to the employer, then the suitability, the capacity of the employee to make use of those tools can be explored. And that's what the employee was asked, assistive tools and training to be able to fulfill his duties. What were those tools? What training would be needed? That only an expert can provide. And that evidence is lacking, in my view, from the discussion in this case. So if all an employer is required to do is to ask the employee to motivate why they are suitable for a position, I'm not convinced that that meets the requirements of what is intended, the Code of Good Practice, either under the Employment Equity Act or, for that matter, under the Labour Relations Act. Of course, for some employers, the cost of engaging an occupational therapist may be relatively significant, and the cost of making the adaptations, the assistive tools and training might be costly. That is certainly something that the employer can raise, but we don't even get to that in this case. It seems that the judge is happy to accept the employer's position, that they asked for a motivation from the employee as to why the employee was suitable for their position, as opposed to getting the evidence of a medical and an occupational expert on what is required in order for the employee to fulfill the position.
You're listening to the Labour Justice Barometer, and we'll be right back. There was basically a lack of a thorough assessment done by the employer. And I think a thorough assessment could have actually just tailored the situation a bit differently. And I think the employee would have probably felt more supported. And like you said, with the advancements in technology, exploring, whether there's certain tools or, training or an expert that could have assessed this in a better way, it might have actually improved the situation for the employee. And a job coach as well could have been a viable solution. And I think it would definitely help to just bridge that gap between the employee's position and capabilities and what the requirements of this role is. So taking all of that into account, Debbie, I have to ask our standard podcast question. On a scale of labor justice, how would you rate it?
On a scale of labor justice, firstly, I think we have a well-developed legal framework. There are some gaps, and we are in the process of domesticating the UN Convention on the Rights of Persons with Disabilities. In terms of our Code of Good Practice under the Employment Equity Act and the Labour Relations Act Dismissals Code, as well as our jurisprudence on the principles of reasonable accommodation and inherent requirements of the job. A concern that I have is perhaps in our implementation of that framework and the sentiment which we see in this quote from the Damon's case. There seems to be a sentiment that somehow forms of reasonable accommodation is giving into an appeal to pity, and somehow that compassion or pity, or feelings of sympathy shouldn't come into the consideration. They shouldn't form a wrong decision. I do worry that we are not engaging adequately with the concepts of reasonable accommodation in terms of just getting an expert in and doing the inquiry properly. And instead we're equating that with, well, this is, pity reasoning to suggest that an employer must go the extra mile. It is not about going the extra mile. It's about ensuring the rights of persons with disabilities. So I do worry that although we have these obligations, there's not a genuine attempt to meet those requirements, as we see in this case. If we ask questions around was there adequate engagement in the process, what aids could be provided, what assistive tools, what would the cost be to ensure that this employee could fulfill either his current role or the ICS role that he was interested in, this requirement that he should motivate for it. My concern just is this precedent that we're setting around what is required by the law. I think the law and the framework under the Employment Equity Act, as well as the Labour Relations Act, is very clear on what that obligation is. I'm concerned about what is acceptable in terms of the employer implementing those obligations.
I'm glad that you mentioned actually Damon's. I mean, the court actually did address Damon's in this case as well. And I think both in this instant, they just share this foundation that we have to address disability related dismissals, especially the extent of reasonable accommodation and this balance of inherent job requirements. And I think what Gugwini and Damons have reinforced is there's just this need for employers to fully engage with employees, exploring all of these accommodations and not just, providing them with accommodations that might not fully aid them or might not highlight what is really necessary, particularly with the role in question. And you're right, the legal framework actually is very comprehensive. It's very advanced. It's in line with international standards. And I mean, we also have the Employment Equity Amendment Act that's going to be in force from 2025. And this definition is going to be updated. The people with disabilities, this definition will actually include people with long-term or recurring physical, mental, intellectual, or sensory impairments. So if our law is, progressing and advancing with international standards and requirements, I think there's this need for employers to do this as well in the workplace, and how they should do this needs to be taken into consideration as well. So I did mention at the start of this episode the Letimile case, and I did give a brief introduction of what this case is about. I did mention that this case is still currently pending before the Labour Court, but I mean, just to give you a brief overview again, and for those listening who aren't aware, I will leave a link about the Letimile case, which is an extremely interesting case. There's so many, key issues that we have to look at with this case. I mean, first of all, there's elements of intersectional discrimination, being a female, being disabled, being a Black woman as well. And, this whole idea that she is essentially dismissed or unfairly dismissed. And I mean, what are your thoughts on this whole decision? There's so many themes, so many aspects to this case.
Asha, this is a very interesting case, and of course there's no decision on it, so there's no, we're not entirely clear how the case has been pleaded, but what's interesting is that, it appears that disciplinary proceedings against her pursued under the social media policy, but it raises, of course, all of those issues that you mentioned around intersectionality. It will be incredibly interesting to see if this is indeed what the Labour Court is required to do, to assess how a company's social media policy needs to be articulated in a way that is not unfairly discriminatory, and whether the application of the policy in fact has a discriminatory impact for those intersectional grounds that you mentioned, a Black woman with disabilities. I think it's a fascinating case, and Ash, I think it's something that we certainly should try and pick up on in a podcast when the Labour Court makes a decision.
I mean, yeah, I 100% agree. I think this is definitely going to be a case to watch. I think it's like we said, there's a lot of themes that we would have to look at, and I mean, it ties in with our discussion today about disability, discrimination, incapacity, all these aspects which are relevant and which I think need to be dived into deeper, especially as we go into the new year. So thanks again for listening today. I think these are really interesting conversations, and thank you again to you, Debbie, for joining us on this episode. All the cases mentioned today will be linked in our description, so please feel free to check those out, as well as the code.
Thank you, Asha. I look forward to speaking to you again soon.
This podcast is not intended to constitute legal advice.